Welcome everybody. How's it going? Great to be learning with you on a Thursday, Yom Hamishi. Let's light up the darkness. Oh. Okay. The troops are gathering here. My dad is coming in. Nina's at the airport picking him up. Nina's mom is in. Our son is graduating from high school. And I just realized that I needed to do what Nina normally does, which is to share this class into a couple of groups. So please bear with me. Into the forum. Share. Sorry. I was supposed to. That's why I have the timer, so I can do things like this. That was the forum. And then we also share it into Torah lessons to help our lives. Post. And one other, a daily dose of Talmud. Come on, Facebook. Come on. Share to a group. Daily dose of Talmud. Post. Okay, thanks for being patient with me. And that also means that at the end of the class, I'll have to scan the comments myself to take the questions because Nina's making the airport run. Okay, Paul in the Great Northwest, Sharon in Las Vegas, Melissa in Great Neck, Billum in Missouri, Shandora in the Bronx, Renee in Indiana, Paula is cooking, Joseph in Massachusetts, Peggy in Colorado, Bella in Florida, Stephen in New Hampshire, at my son's high school graduation. So we're at that same stage of life. Stephen, mazel tov, congratulations. Lucy in Minnesota. Where'd it go? It skipped on me again. Lucy in Minnesota. John in Maine. Getting lots of mazel tovs. Welcome, everybody. It's so great to have you with us. Also, Ella saying shalom. Marjorie in Georgia. Lynn in North Texas. Spencer says shalom from smoky West Hartford. Please, God, may all that smoke resolve. May the fires be put out and no one get hurt. Aoife checking in from Florida. Welcome, everyone. All right. We are making our way towards the end of chapter 2 here in Tractate Gittin, the 19th volume of the Talmud, the laws of the get, the bill of divorce. We are continuing our discussion of Mishna number 5 here in chapter 2, and then we'll get into Mishna number 6 as well. Mishna number 5 said that anyone is qualified to write a bill of divorce, even people who are normally disqualified from serving as witnesses in a beis din, in a rabbinic court, like a deaf, mute, an imbecile, or a minor. And even a woman can write her own bill of divorce, as we saw. I mean, she has to then give it to the husband, and then he has to fill in the important parts. And so they're making this distinction between a bill of divorce has to be written, right, by a particular man for a particular woman. They can't take just some kind of template get off the shelf and then the husband just gives it to her and says we're divorced. It has to be a specific get that's written by this man for this woman. But what does it mean that he writes it for her? It doesn't necessarily mean that he writes the entire document. Some of it can be written, the non-essential parts, what they refer to as the standard part, the kind of same language for everybody. That doesn't have to be written by him. In fact, she could write it, or she could have a scribe write it. Then she has to freely give it to the husband so that it becomes his property, so that he can then fill in the essential parts. His name, her name, and his signature, and the witnesses signing it, and some particular language that we're going to encounter today. And then he gives her that get that he wrote, in this sense, specifically for her. So we pick this up on page 23a, a few lines from the top. With regard to the requirement that a get be written for her sake, right, lishma, for her sake, Rav Nachman says that Rabbi Meir would have said, even if the husband found the bill of divorce in the garbage dump and the names written on it happened to be the same as his and his wife's names, if he had it signed by witnesses and he gave it to her, then it is valid, because the essential requirement is that it be signed for her sake. Now, we've been saying over and over again, no, it has to be written for her sake. Is it enough that it was simply signed with the intent that it was for this woman alone? Well, Rava raised an objection to the statement of Rav Nachman. The verse states in the Torah, and he writes her. He writes her a bill of divorce, right? The husband writes her. It's a specifically written bill of divorce for her. So how can you say it only has to be signed for her sake? The Torah says it has to be written for her sake, says Rava. And what? Is it not referring to the actual writing of the get, that it must be written with the intent that it be used to sever this particular marriage? But the Gemara rejects this argument of Rava. No, it is only referring to the signing of the witnesses that has to be done specifically for this marriage. So Rava raised another objection based on what was taught in the Mishnah on page 24a. Any bill of divorce that was not written, as opposed to signed, that was not written for a specific woman, is invalid. So he responded, say that according to Rabbi Meir, the Mishnah teaches any divorce that was not signed for the sake of a specific woman is invalid. Okay, according to Rabbi Meir, but maybe not the majority. So Rava raised another objection to him based on a different baraisa. When the husband writes it, it is as though he writes it for her sake, meaning that writing one part for her sake makes it as if the entire document was written for her sake. And what? Is it not stating that when he writes the essential part of the get, which includes the names of the spouses, the date on which it was written, and the expression, behold, you are permitted to any man? Right, that's the essential operating language of the get. Aside from the names of the husband and of the wife and the date on which it was written, and then the signature of the husband and the signature of the witnesses, the real operative language is, behold, you are permitted to any man. That's the opposite of being married. When you're married, she becomes prohibited to every other man on earth and permitted only to her husband. When she receives the get, she's now permitted to any man and prohibited to the husband unless they remarry. Well, I guess they could remarry. So she just becomes permitted to any man. Obviously, that doesn't mean that she has sexual relations with any man. It means that she's not permitted to marry any man, which was not the case when she was married. So Rava is saying here, well, perhaps what we ought to learn out from this is that when this language is written for her sake, maybe even any part of that essential language is written for her sake, it's as if the whole get was written for her sake. So this baraisa indicates that there is a requirement that the get, and not just the signatures, be written for her sake. But Rav Nachman rejects this argument. No. Rabbi Meir would explain that this baraisa is referring to a case where the husband has witnesses sign it for her sake. And it is as though he wrote it for her sake. And if you wish, say, who is the Tana, meaning the rabbi of the Mishnah, of these baraisas, right? Baraisas are contemporaneous with Mishnayos, right? Plural Mishnah, of Mishnah. So Mishnahs are the teachings prior to the year 200 of the Common Era, right? Then they publish the Mishnah, and then the next round of commentary is the Gemara. But there are baraisas that are from the same period as the Mishnah, and they are deemed not quite as authoritative as Mishnayos, because Rabbi Yehuda Hanassi, who redacted the Mishnah, didn't see fit to include them in the Mishnah. Right? The word Mishnah can both mean a particular Mishnah, a particular teaching, and the whole collection of Mishnayos. So sort of capital M Mishnah is the whole collection. Little m Mishnah is any particular Mishnah. So a baraisa is of the same stock as the Mishnayos, but for whatever reason, Rebbe didn't see fit to include it in the capital M Mishnah. Nevertheless, we always refer to baraisas because I know you all know this. I refer to baraisas constantly, but for anyone who's new here, I'm just telling you what a baraisa is. And so we've often learned out, we sort of compare a particular Mishnah to baraisas that are similar with it, baraisas that are similar to it, and we might be able to learn exactly what was the intent of the Mishnah, as we're doing here. So, Rav Nachman rejects this. No, Rabbi Meir would explain that this baraisa is referring to a case where the husband has witnesses sign it for her sake, and then it is as though he wrote it for her sake. And if you wish, say, who is the Tana of these baraisas from which you raise challenges? They are in accordance with the opinion of Rabbi Elazar, who said witnesses of the transmission of the bill of divorce effect the divorce. According to him, the verse is referring to the writing and not the signing of the bill of divorce, and the writing must be for her sake. Bottom line, we have sages disagreeing with each other about, we know that basically, a get must be created for the sake of a particular woman with her in mind. The husband has to have that get created in order to effect this divorce with his wife, and it can't be some off-the-shelf get that wasn't created for her sake. So what does created for her sake mean? Does it mean that it was mostly written and then the husband added her name and his name and signed it and the witnesses' signatures, and then we can say it was written for her sake? Or does it mean that all of the text or a large part of the text was exactly written for her sake? They're arguing about that and continue to argue about that. And Rav Yehuda says that Shmuel says, and the statement of the Mishnah, that one who is not halakhically competent is nevertheless qualified to write a bill of divorce, is the law only when the husband left unwritten the essential part of the document, the names, the date, the operative sentence, and the signatures, which will be written later by a halakhically competent person. So obviously we're not talking about the signatures there, but the language, behold, you are hereby permitted to any man, and the names of the husband and wife, that could be written by any halakhically competent person. That could be written by a that must be written by a halakhically competent person. And the halakhically incompetent people can write other parts that are not the essentials of the get. And so Rabbi Chaga says in the name of Ula, and this is the law only when he left the essential part of the document unwritten. And the Mishnah is in accordance with the opinion of Rabbi Elazar that the writing of the essential part must be done for her sake. And Rabbi Zarika says that Rabbi Yochanan says it is not Torah. The Gemara clarifies what is meant by the expression, it is not Torah. And Rabbi Abba says here, Rabbi Yochanan informs you that there is no force to a requirement that a bill of divorce, that a get, be written for her sake, as only the signing needs to be done for her sake. And it is in accordance with the opinion of Rabbi Meir, who says signatory witnesses on the bill of divorce effect the divorce, right? Remember this essential dispute between Rabbi Meir and Rabbi Elazar. Rabbi Meir says the essential moment, like the moment that effects the divorce, is when the witnesses sign the get, right? That it was written for this woman and delivered. When they sign it, that's when the divorce really becomes a divorce. And Rabbi Elazar says it's when a properly written and signed get is delivered into her hand. That is when the divorce is effected. And the Gemara asks, but didn't Rabbah Bar Chana say earlier that Rabbi Yochanan said that the Mishnah is in accordance with the opinion of Rabbi Elazar, that delivery affects divorce? How then can Rabbi Abba say that according to Rabbi Yochanan, the Mishnah is in accordance with the opinion of Rabbi Meir? And the Gemara answers, they are Amoraim, rabbis of the Gemara period, and they disagree with regard to the opinion of Rabbi Yochanan, whether he explains the Mishnah in accordance with the opinion of Rabbi Meir or that of Rabbi Elazar. And that's where this discussion ends. Here comes Mishnah number 6 of chapter 2. Anyone is fit to serve as an agent to bring a bill of divorce to a woman, except for a deaf, mute, an imbecile, a minor, or a blind person, or a gentile. Right? So anyone can serve as the agent of delivery to the wife, properly written get. Now it has to be given to her. And it's going to have to be witnessed, right? So normally one of the witnesses would act as this agent, but not necessarily, right? So they're going to be witnesses of the delivery, and once it's handed to her, it is also read in her presence. But the person who hands it to her does not have to be a halakhically competent person, or they do. Anyone is fit to serve as an agent to bring a bill of divorce to a woman, except, right? So we don't allow halakhically disqualified people from serving as the agent to bring the get. Deaf, mute, imbecile, minor, but also a blind person and a gentile are added to the list. Now, if a minor received the bill of divorce and then reached the age of majority, or one received it when he was a deaf mute and then he became able to hear, or one received it when he was blind and then he became able to see, or one received it when he was an imbecile and then he became halakhically competent, or one received it when he was a Gentile and then he converted and became a Jew. In all these cases, he is unfit to bring the bill of divorce because, as we see, he has to be qualified, the same kind of person that can serve as a witness in court, to receive the get from the husband and hand it to the wife. However, says the Mishnah, if one received it when he was able to hear and then he became a deaf mute and then again became able to hear, or if one received it when he was able to see, then he became blind and then he regained his sight, or one received it when he was halakhically competent, then he became an imbecile, and then he became again halakhically competent. In all these cases, he is fit to bring the bill of divorce, and this is the principle. Anyone who is halakhically competent in the beginning and in the end is fit to deliver the get to the wife. That's Mishnah number 6. Here comes the Gemara. So the Gemara begins by asking, with regard to those that the Mishnah lists as not being qualified to bring a get, granted, a deaf mute, an imbecile, and a minor are not qualified because they are not halakhically competent, and only one who is competent can be appointed as an agent. Additionally, a non-Jew also is not qualified, as he is not subject to the laws that permit a woman to remarry via a bill of divorce. A person cannot serve as an agent for a matter that does not apply to him, right? The laws of Jewish marriage do not apply to non-Jews. And what they want is that the one who's delivering the bill of divorce is someone who is also subject to the laws of Jewish marriage, like the Jewish husband who's now sending this get to his Jewish wife. Okay, so wait a minute, where am I? So granted, right, the deaf mute, the imbecile, and the minor are just halakhically not competent. They can't testify in a rabbinic court, and they can't deliver the get. And it makes sense that a non-Jew also is not qualified to deliver the get because the laws of Jewish marriage do not apply to him. But why is a blind person not qualified to bring a bill of divorce? Rav Shesha says because he does not know from whom he takes the bill of divorce and to whom he gives it. And since he is unaware of this, he will not be able to testify about it. And Rav Yosef immediately objects to this. Well, if there is a concern that a blind person cannot distinguish between different people, now Rav Yosef is going to ask sarcastically, then how is a blind man permitted to have sexual relations with his wife? How does he know that she is in fact his wife? And similarly, how are all people permitted to have sexual relations with their wives at night, given that they're making love in pitch dark, which is what you're supposed to do. You're supposed to only make love in the dark. And if it is dark, they cannot see them. So if you're going to say that a blind person can't deliver a get because he doesn't know who he's giving it to, how could you allow a blind person to make love to his wife, or for any people to make love in the pitch black when they can't see each other? Rav Yosef is asking this very sarcastically because obviously we allow a blind man to make love to his wife. Obviously we allow husbands and wives to make love to each other in the dark. And obviously, according to Rav Yosef, a blind person knows who he's delivering the get to, and he is permitted to deliver the get, which is in fact the law. But watch how Rav Yosef continues his proof. Rather, says Rav Yosef, you must say that they are permitted through voice recognition. Teviut eina dekala. And they recognize each other based on their voices. And here too, with regard to a blind person, he can recognize both the giver of the get and the receiver of the get through recognizing their voices. Therefore, says Rav Yosef, here we are dealing with a husband who sends a bill of divorce to his wife outside of the land of Israel, where the agent of delivery needs to say, it was written in my presence and it was signed in my presence. And here the blind person has a problem. The blind man cannot say this because he is unable to see what is being written or signed. If the get was written in Braille, then he could testify that it was written in my presence and signed in my presence because he could confirm that. Since he can't confirm that it was written in his presence, that's the problem. But remember, the agent of delivery testifying it was written in my presence and signed in my presence only applies to a get that's coming from outside of Israel into Israel or vice versa. You don't need that when a get is being given by a husband to a wife directly, right? And so within Israel. So certainly the blind person could function as the agent of delivery in that situation. Now, Abaye said to Rav Yosef, wait a minute. If that is so, then a person who is able to see when he receives a bill of divorce and then he becomes blind, so he can say it was written in my presence and signed in my presence, as he was able to see when it was written and signed, would you say that he is also fit to bring the bill of divorce? But it was taught in the Mishna. If one received it when he was able to see, and then he became blind, and then again became able to see, then he is fit to bring the bill of divorce. And from this it can be inferred that only because he became able to see again, he can deliver it. But if he was sighted when he saw the bill of divorce being written, and he was blind when it was time to deliver it, this implies that he would not be allowed to deliver it. And the Gemara answers this question. In fact, with regard to a blind person, the same is true, that although he did not again become able to see, he can serve as an agent to bring the bill of divorce and testify that it was written and signed in his presence. He can. So as long as he saw it written, if he's blind at the time of delivery, he remains qualified to hand the wife the bill of divorce. He can talk to her and ascertain that it's her. And why does our Mishnah teach that a blind man became able to see again? Because the Mishnah teaches that one who received the bill of divorce when he was halakhically competent, and then he became an imbecile, and then again became halakhically competent, is qualified to bring the bill of divorce. And in that case, the reason why he's qualified is specifically that he again became halakhically competent. But if he did not again become halakhically competent, then he is not qualified. Therefore, the Mishnah also teaches with regard to one who was able to see, and he then became blind again, and then he became able to see. And Rav Ashi says the language of the Mishnah is also precise, as it teaches that this is the principle. Anyone who is halakhically competent in the beginning and in the end is fit. And it does not teach anyone who is fit in the beginning and in the end is fit. Learn from the Mishnah that it is not necessary for him to be fit in the beginning and the end, as there are times that being fit in the beginning is sufficient, as in the case of one who became blind after witnessing the writing and signing of the bill of divorce. However, it is clear that he must be halakhically competent both in the beginning and at the end, which a blind person is, right? A blind person is halakhically competent. He is different than an imbecile or a minor. They raised a dilemma before Rabbi Ami. With regard to a slave, what is the law? Can he be made an agent to receive a get from the hand of her husband? Can he receive a get on behalf of his mistress, who is the wife? Can he receive as her agent? Can he receive the get from her husband? Is he qualified to act as an agent or not? So Rabbi Ami said to them, from the fact that the Mishnah disqualified a non-Jew, one can learn by inference that a slave is fit. And Rav Asi says that Rabbi Yochanan says a slave cannot become an agent to receive a bill of divorce for a woman from the hand of her husband because he is not included in the laws of divorce and betrothal. And one can act as an agent only in a matter that applies to him, right? That was the reason that a Gentile cannot act as the agent of delivery, because he's not subject to the laws of Jewish marriage. Is a slave subject to the laws of Jewish marriage? No, because he's a slave, right? We don't have slavery anymore. Thank God we haven't had it in thousands of years, but when it existed, this is the way that it was dealt. Now, Rabbi Elazar objects to this explanation as to why a slave cannot act as an agent. By the way, we're on 23b now. The reason that a slave is unfit is that this agency pertains to a matter whose laws he's not included in. But for a matter whose laws he is included in, like a mitzvah that applies to a slave, is he fit to serve as an agent for that? But what of a Gentile and a Samaritan who are included in the laws of teruma with regard to their own produce, i.e., they must designate a portion of it for the priest, as we learned in a Mishnah. Right? Remember that what is teruma? Teruma is when the temple was standing. Tragically, it was destroyed nearly 2,000 years ago. But when the temple was standing, so if you grew crops in the land of Israel, you would set aside the first 2% of the produce as teruma. That was consecrated food, and it could only be eaten by priests, right, kohanim, and their households, including a slave. Right, a slave might have very few rights, compared to free people, but the slave of a priest can eat teruma, whereas a free Jew who's not a Kohen and who's not the slave of a Kohen cannot eat teruma. Only the household of a priest can eat teruma. But the slave who receives this food, he himself has to set aside teruma, right, for a priest. Now, this is only the law within the land of Israel. But what of a Gentile and a Samaritan, right? So these are non-Jews. The Gentile is, it's just a non-Jew by definition. And the Samaritans, as we've talked about, this was a population that was brought into Israel at the time the Assyrian exile, when the 10 tribes were exiled, the Assyrian conquest. The 10 tribes, which became the lost tribes of Israel, were exiled out of the northern kingdom. And then the land was sitting empty. So the people that conquered Israel at that time brought in these other people called the Samaritans. They were non-Jews who eventually, because it seemed like the land was rejecting them, they were being attacked by lions, they did a conversion under duress to Judaism, but they never fully saw themselves as Jewish. They only sort of followed the laws of the written Torah. They didn't accept the authority of the rabbis and the oral tradition. And so eventually they were just considered non-Jews, even though they followed many of the same mitzvahs as all Jews, but not all of them. And for that reason, they weren't considered Jews. So what about the Gentile and the Samaritan, who are included in the laws of teruma with regard to their own produce? As we learned in that Mishnah, with regard to a Gentile and a Samaritan that separated teruma from their own produce, their teruma is teruma. Meaning a priest can receive that teruma, and it is considered teruma, and it has to be eaten where the teruma itself is in a state of ritual purity, and the priest who's eating it is in a state of ritual purity. And yet we learned in a different Mishnah, in the case of a Gentile who separated teruma from a Jew's produce, i.e. acted as the agent of the Jew, even if he did so with the permission of the Jew, his teruma is not teruma. Why is this? So a Gentile can, in certain situations, can separate teruma from his own produce, and that becomes teruma. But if he acted as the agent of a Jew with the Jew's permission to separate teruma from the Jew's produce, somehow that disqualifies that teruma as teruma. What is the reason for this? Is it not written, you, in the verse that is the source for the laws of agency, right? Numbers 18:28. So you shall set apart a gift unto the Lord of all your tithes, right? So you also shall set apart a gift, meaning you shall set it apart, right? You won't have somebody do it for you. Now, does that mean that every rich person who owns many, many fields has to personally go in and separate the teruma? No, but he can only appoint a person who is like himself to the exclusion of the non-Jew or the Samaritan. So just as you, the ones appointing the agents, are Jews, so too your agents for this job of separating teruma must be Jews. Since slaves are not full-fledged Jews, even though some laws apply to them, not all Jewish laws apply to them, they should be disqualified from ever acting as agents, even in a matter in which they are included in its laws. Right? So even though some of the laws of teruma apply to slaves and to Gentiles and to Samaritans, that doesn't mean that all Jewish laws do, obviously, and so they can't act as an agent of a Jew for things that only Jews can do. Now, the sages from the school of Rabbi Yanai said, no, the verse should be expounded differently, like this. Just as you, the ones appointing the agents, are members of the covenant, meaning you're a Jew, and the covenant applies to you, so too, your agents must be members of the covenant. Gentiles cannot serve as agents because they are not members of the covenant. Slaves whose masters are commanded to circumcise them and who are obligated in some of the mitzvahs are members of the covenant, and they can serve as agents in a matter in which they are included in its laws. So the Gemara quotes the laws of marriage don't apply to them, but the laws of teruma do. So maybe a slave can separate teruma on behalf of his master, even though a non-Jew could not. Now the Gemara quotes a related statement. Rabbi Chia bar Abba says that Rabbi Yochanan says, a slave cannot become an agent to receive a bill of divorce for a woman from the hand of her husband because he, the slave, is not included in the laws of divorce and betrothal. And although we learned, if a person said to his female slave, behold, you are still a maidservant, and your unborn child is a free man, if she was pregnant at that time, then she acquired freedom for the unborn child, right? So a pregnant slave, she's a slave, but the owner can say to her, when your child is born, he's free. I free the embryo now. Right? And so at that point, so he said it to the slave, not to the embryo, but therefore she's acting as an agent of a fellow slave, in this case, her unborn child. So the Gemara first clarifies, what is the connection between the initial statement of Rabbi Yochanan and the clause, if she was pregnant at that time, she acquired freedom for the unborn child? When Rav Shmuel bar Yehuda came, he said, Rabbi Yochanan said two distinct statements. The first statement was that a slave cannot be appointed as an agent to receive a bill of divorce for a woman from her husband. And the other statement was, it appears that a slave can receive a bill of manumission for his fellow slave from the hand of his fellow's master, but not from the hand of his own master, if both of them were enslaved by the same person. And if a person will whisper a question to you saying, this ruling, that a slave cannot receive a bill of manumission for his fellow slave from their common master, this is difficult, as a law was taught that states the opposite. If a female slave was pregnant, then she acquired freedom for the unborn child if the master said, your unborn child is free. So then she acquired the child's freedom on its behalf. And they obviously have a common master since the master owns her and her unborn child. So if someone says that, then say to him that two greats of the generation already explained the matter, and they are Rabbi Zera and Rabbi Shmuel bar Yitzchak. Rabbi Shmuel bar Rav Yitzchak. One of them said, in accordance with whose opinion is this? It is in accordance with the opinion of Rabbi Yehuda Hanasi, who says, with regard to one who emancipates half of his slave, the slave acquires freedom for half of himself. Right? You could have a slave that is owned by two masters. So if a slave says, I hereby free you, if the master says, I hereby free you, now he can't free the half of the slave that is owned by a different master, right? The slave is co-owned by two masters. So one of them can say, I free you. What he's done is he's freed the half that he owns. So now you have a person who is half slave, and half free. And that is actually one of those, unusual states of being that are very interesting under Jewish law, and so it gets mentioned often in the Talmud. So with regard to one who emancipates half of his slave, the slave acquires freedom for half of himself. And one of them added an explanation, one of these sages, and said, what is the reasoning of Rabbi Yehuda Hanasi for this ruling? He holds, a fetus is considered like its mother's thigh, i.e. part of its mother's body. And it is as though the master transferred ownership of one of her limbs to her. Since the maidservant is pregnant, the child is considered to be part of her, and it is as though he emancipated a portion of her body. Therefore, the mother is not acting as an agent on behalf of the unborn child. Rather, she's receiving partial freedom for herself. Which part of herself? This unborn child, which when it emerges from her, will be a free person and not a slave. But we can't learn out from that one slave can receive a bill of manumission on behalf of another. We haven't learned that. At any rate, that was a bit of a digression, because what we're really talking about is who can receive a bill of divorce on behalf of a woman. And it sounds like anyone except the deaf mute, the imbecile, or the minor, and the gentile, right? Those are the people who can receive. And what about the slave? Did we exclude a slave? Not from the Mishnah. So we don't really know if the slave can receive the get on behalf of the wife or not. We seem to have some split opinions on that. But that's where we leave off the discussion of Mishnah number 6. Here comes Mishnah number 7. There are instances in which a woman's testimony that another woman's husband has died is not deemed credible. We studied that when we were in Tractate Yevamos. And remember there, the idea was that normally, when does a woman legally become a widow, right? Obviously when her husband dies. But what if we don't know if her husband died or not? So if two people come and say, we witnessed that your husband died, now she's legally a widow. She can go and remarry. And if by some weird turn of events, it turned out that those two witnesses were lying or were mistaken, and the husband comes back, she hasn't done anything wrong. She might have to divorce the second husband, but the children of the second union, I don't even know if she has to divorce the second husband, and certainly the children of the second union are not considered mamzers, children born of adultery. If only one witness comes, she is allowed to remarry. And that was a leniency that the sages decreed. Or normally you can only do something, you can only establish something important like this, that she's legally a widow, by the testimony of two witnesses. However, it might be that her husband died in some far-off land, and only one person comes from that far-off land and says, I saw your husband die. There's not going to be another witness coming. And if we don't let her rely on the testimony of a single witness, she'll be an agunah. She'll be stranded. She'll never be able to start her life again and remarry, etc. So we allow this to happen on the testimony of one witness. If she does it, she's taking a chance. If the husband then comes back, the second marriage is considered like it never happened. She'll have to formally get a divorce just in case. But the children of that second union would be mamzers. So it's terrible, terrible consequences if it turns out that the husband was not in fact dead. Nonetheless, that usually doesn't happen, and we allow her to rely on the testimony of the single witness. However, if that single witness, and that single witness can be a woman, but it cannot be a woman who is one of her close relatives, and that's what this Mishnah is now going to explain. There are instances in which a woman's testimony that another woman's husband has died is not deemed credible. If there is a presumption that due to their familial relationship, the two women might be jealous of each other, might even hate each other. There is concern that the woman is testifying falsely in order to harm the woman who would remarry based on the testimony of this single witness. Because if her original husband then proves to be living, she will be required to leave her second husband. So this Mishnah teaches even the women who are deemed not credible to testify on behalf of a woman and say that her husband died, nonetheless, these women are deemed credible to be the agent of delivery for a get. The relatives of the woman who are not deemed credible to testify that her husband has died are her mother-in-law and her mother-in-law's daughter and her rival wife, right? Like, because in ancient times you could have two wives, so you can't accept the testimony of your co-wife, your rival wife, that the husband died. And her Yevama, i.e. her husband's brother's wife, and her husband's daughter. All these women are disqualified from being the single source of testimony that this widow's husband has died. This possible widow's husband has died. Now the Mishnah explains, so what is the difference between a bill of divorce and death? That certain women are deemed credible to testify about one, but not the other. With regard to a get, a bill of divorce, it is so that the writing proves that the husband is divorcing his wife, and the testimony is needed only to supplement the get. Similarly, the woman herself may bring her own get, provided that she is required by the court to state in the court's presence, that it was written in my presence and it was signed in my presence. That's the difference. There's more evidence that the husband sent the bill of divorce. There's the get itself, the witnesses, etc. Whereas when we only have the testimony of a single witness that a man died, that witness's testimony is so exponentially more important, and that's why we're not going to rely on a person who might have a real grudge against the woman who needs that testimony and might provide it falsely and thereby harm this woman. That's the Mishnah. Here's the Gemara. The Gemara asks, but isn't it taught in a Baraisa, just as these women are not deemed credible to say her husband died, so too they are not deemed credible to bring the get? And Rav Yosef said it is not difficult. Here, this Mishnah is referring to a case that took place in the land of Israel. And there, the Baraisa is referring to a case that took place outside the land of Israel. And the Gemara explains the difference. In a case that takes place in the land of Israel, where to validate the bill of divorce, we do not rely on the statement of the one who brings it to say it was written in my presence and signed in my presence. But rather, when it's within the land of Israel, she's only the agent of delivery. Her testimony doesn't matter. However, in a case that takes place outside the land of Israel, where we rely on this statement of the agent of delivery that it was written in my presence and signed in my presence, there that person's testimony takes on much more significance, and we would not rely on the testimony of someone who might well have a grudge against the woman. So Abaye said to him, on the contrary, the opposite is more reasonable. And the distinction should be in the land of Israel, where if the husband were to come and contest the validity of the bill of divorce, we would pay attention to him and rule that they are not divorced, where it could be said that the woman who hates her intends to do her harm by having her remarry based on a bill of divorce that was later contested, she is not deemed credible. However, outside of the land of Israel, where if the husband were to come and contest the validity of the bill of divorce, we would not pay attention to him. She is deemed credible, as she does not have the power to make trouble for the other woman and cause her to have to leave her second husband. So the Gemara notes that it is taught in a Baraisa in accordance with the opinion of Abaye. Rabbi Shimon ben Elazar says in the name of Rabbi Akiva, a woman is deemed credible to bring her own bill of divorce through the Kal V'chomer inference and a fortiori inference, just as women about whom the sages said they are not deemed credible to say her husband died are nevertheless deemed credible to bring the get. With regard to the woman herself, who is deemed credible to say that her husband died, is it not right that she is deemed credible to bring her own bill of divorce? And now we're just going to go a little bit into 24a, because tomorrow's daf is very long, and we're going to be meeting at Friday, the regular Friday time at noon. And from the place that you came, i.e. from the inference itself, one establishes, just as there, those who bring the bill of divorce must say it was written in our presence and was signed in our presence, so too she herself must say it was written in my presence and it was signed in my presence. And this Baraisa must be referring to a case in which the wife brought the bill of divorce from outside of Israel into Israel, as it is only then that she must make the declaration, written in my presence and signed in my presence. Therefore, the Baraisa appears to support the opinion of Abaye. Rav Ashi said, right. And the Mishnah is also precisely formulated in a way that supports Abaye's opinion, as it teaches the woman herself may bring her own get, provided that she is required by the court to say it was written in my presence and was signed in my presence. Learn from the Mishnah that it is referring to a case outside the land of Israel, as Abaye explained. So then the Gemara asks, but according to Rav Yosef, is it possible to say that the first clause of the Mishnah, anyone is fit to serve as an agent to bring a bill of divorce, and the last clause of the Mishnah, that the woman herself may bring her own bill of divorce, discuss a case that is in a location outside of the land of Israel? The beginning clause and the last clause are talking about a case of a get brought from outside of Israel. But the middle clause, even the women who are not deemed credible, discusses a case that takes place in the land of Israel. Are we shifting our understanding of what's being taught here from one to the other? That the first and last clauses are talking about a get being brought from outside of Israel, and the middle clause is about a get being brought from within Israel? Is that really how it's formulated? And the Gemara answers, yes. The first clause and the last clause discuss a case that takes place in a location outside of Israel, but the middle clause discusses a case that takes place in the land of Israel. Now I'm almost done. Questions or comments, get them in. And the Gemara explains, from where does Rav Yosef infer this? From the fact that it teaches in the Mishnah, what is the difference between a bill of divorce and death? That certain women are deemed credible to testify about one but not the other. With regard to a bill of divorce, it is so that the writing proves that the husband is divorcing his wife. The Mishnah does not teach that the writing and statement of the agent of delivery prove this. Consequently, the statement of "it was written in my presence" is not needed. And this indicates that the Mishnah, in its middle clause, is discussing a case that takes place in the land of Israel. I don't know what's going on. There's a weird rumble in the room. Anyway, let's go to some questions or comments. Nina is doing an airport run, picking up my dad. So I'm scanning the comments on my own, which is not easy. Let me see if I can do that. Sharon comments that I just finished Darrell Horn's book, People Love Dead Jews, which ends with how redemptive Daf Yomi is for her. The book is challenging, but excellent. Thank you for that recommendation. And Joseph says, I suppose this declaration of permitted to any man or forbidden to other men language can sort of be a definition of marriage. Correct. Right? Correct. That's exactly right. Joseph says, Nina, I can't seem to see the past videos on your YouTube channel. They're all there. I don't know why they wouldn't be there. They're all there. And by the way, you can always find all of the past classes with links to both Facebook and YouTube on our website at accidentaltalmudist.org. And there's, they're all organized by track date, and there's links to all earlier shows. If there's ever a page you want to learn, outside of our daily routine, and you're wondering, if I've taught it, there's a record of every page. We taught every page. Sometimes they were done as highlights. Well, we did skip a few pages, that is true, while I was directing the movie. But other than that, other than those like 2.5 months, I've taught every page of the Talmud, mostly complete pages, sometimes highlights. In the beginning, the very beginning, we were doing kind of highlights of the pages, but pretty quickly we started doing the whole page. So anyway, at accidentaltalmudist.org, you can go to the section on AT Daily and find a record, links to all of the earlier shows. Sharon says, we talked before about hearing the sound of the writing as adequate. Why is it not here? Great question, right? We saw that in terms of it was written in my presence and was signed in my presence, all the guy had to do was be in the house when it was being written, and that he could testify that. But I think what they said there is that, he was present. Maybe he saw some of it being written, or at the very least, the people who were writing it knew that this guy could come in and look at it at any time. So it was like they were supervised and they wouldn't have willy-nilly, just wrote stuff in it that was forged or was a lie. Whereas if a blind person was there, they would know that they could write a lie and get away with it, and the sound of writing wouldn't protect the recipient, the woman who's going to eventually receive the get from that. So that's why it's to protect her that you would rather have, a halakhically competent person, and a blind person can deliver the get, but he would have to have been cited at the time that it was written in order to be able to state it was written in my presence and signed in my presence. And of course, that would only apply to a get that's coming into Israel from outside of Israel when that statement is required. And Bill says, because YouTube is sometimes just as glitchy as Glitchbook. And how? That's what I've got for us today. With God's help, we'll be together again tomorrow for page 24. And with that, we will complete chapter 2 of Tractate Gittin. Tomorrow's the Friday class, regular Friday time, noon